Hello, my name is Mark Nacol. If you don't have an employment contract, you can be fired because of that pimple on the side of your face that your boss hates, or simply because he doesn't like the dress you wore that day. It's perfectly legal, and there's nothing you can do about it. Now, there are federal exemptions. If you're also very, very old, and you're fired and replaced by somebody very, very, very young, as long with everybody else your class and category in the company, you may have a claim. If it's a racial issue, you may have a claim. If you're fired because you're disabled, you may have a claim. If you're fired for refusing to commit an illegal act, you have a claim. Those are valid claims, but it's rare that that type of sexual, racial discrimination can be proved without spending a lot of money. I would prefer, and I think you would prefer, to have an employment contract. You would like to have the core reasons, the consideration, the termination, the notice, severance, the core tenets of your relationship spelled out in writing and signed. Even if it's 90 days, 180 days, a year, it doesn't matter what the term is. Employment agreements are especially significant if you are asked to restrict your right to work in the future. Covenants against competition change yearly in the law. If one is drawn, or if you're seeking to enforce one, you need to be very specific, very limited in the duration extension of where the employee of yours can or can't work and for how long. The harder you push, the more likely you are to fail in that regard. And the case law is changing as I speak. But generally, non-competition clauses are recognized. If you are an employee, don't sign it. If you're an employer, make sure what is signed is enforceable.